Hi, thank you so much. I'm Kate Federoff, and I am from Town Council's office. And I've been asked to give an open meeting law and ethics training to you folks. Thank you all for coming. I know a few of you, but would you raise your hand if you're a staff member? Your staff. Okay, so just one staff, and all the rest of you are on boards and committees. Okay, I just kind of. Okay, staff. Okay, so we've got a equal split. I just wanted to see what my audience was looking like. Either way, the ethics law applies to all of you. So there are three general types of restrictions that are fall within the ethics law, and they're on-the-job restrictions, off-duty restrictions, so after-hour service, and after-service restrictions, so once you've left your board or committee or left the employ of the town. It is important to note that every situation may have small facts that change the analysis, because this is an area of the law where they're not necessarily bright line rules. So if you're coming into a situation that's giving you pause or you're hesitating, it's important to reach out to us. You'll speak to the town administrator to get permission to contact us, or speak to the Ethics Commission directly, because there are all kinds of factors that play into whether or not there's a violation or not, whether or not you need to file a disclosure or not. So be mindful of that this is kind of just a broad outline of what you're obligated to follow. So what is a municipal employee? And that's virtually everyone who touches the town. So it's your part-time employees, it's your full-time employees, it's your paid staff or unpaid volunteers. It's your board members, whether they're appointed or elected, whether they're paid or compensated. It could implicate your outside consultants, so your engineers that you may hire as a board or committee. All of those folks are considered municipal employees, even though in the traditional context you wouldn't think of them as being employees. But generally, be cautious and consider yourself an employee. There are certain exceptions, but they're not worth highlighting. And know that you are obligated to comply with the law. So first we'll deal with the on-the-job restrictions. The first issue, which may seem obvious, are bribes. So you're not allowed to receive anything in exchange for your position. So if you're a staff member or if you're a board member, don't accept a bribe. And remember, a bribe isn't necessarily something that's strictly monetary. It could be other kind of more subtle things that are asking you to do something in exchange for something else. Gifts. You can't accept a gift over $50, okay? And again, it's not necessarily someone coming in with a $50 bill, but rather it could be something more innocuous like discounts. It could be in-kind gifts, so, chocolates or whatever. It could be meals, so your engineer says to you before the meeting, let's go and grab a bite, and takes you out for a $100 steak dinner. Not appropriate. Again, there are certain exemptions that exist. So if you're going to a training or if you're speaking as an expert, say you're a conservation agent, you're speaking as an expert in a panel, they may comp you your travel, or they may comp you a hotel or something like that. So there are certain exceptions that would apply if you're acting in your official capacity. And this holds true too, even if you're going to, say, a charity event. If you're doing a service for the charity, like speaking at the event or serving as the MC or something like that, they can perhaps comp you your ticket. But just because you're an elected official doesn't mean that the charity should comp you your $75 ticket to the fundraising gala. that you've been invited to. So be careful of some of the more subtle things that don't necessarily jump out at you. Again, here's an example of something that seems innocuous. The employee gets pulled over by a police officer and convinces the town police officer not to issue the ticket. That's using your position because he knows that you work for the town. He may drop off payroll and you pick up payroll and you know the guy, but it's not appropriate for him to give you that benefit. He hasn't given you money, but he's given you a benefit. In addition, another thing that constantly comes up is just using town resources, and that can be anything from the printer to the computer to other employees. So you shouldn't use that for your private and personal use because that's also a violation of the conflict of interest laws. Self-dealing. You may not participate in any matter in which you're involved or your immediate family is involved or your business organization is involved or future employment. Now, immediate family member is a really narrow category of people. So that's your spouse, it's your parents, it's your children, and I'm forgetting someone else. Siblings, your brothers and sisters. So those are the folks that constitute your immediate family. Now, if it's your cousin and you act on an application, you wouldn't be in violation of this provision of the conflict of interest law, but you may be in violation of another provision, which we'll get to shortly. But know that that is a very narrow definition. Now, what does it mean to have a financial interest? And this is something that is not always clear because it can be positive or negative. It can be a small amount of value or a huge value. It doesn't matter so long as there's some sort of change. So for example, it could be something that if you're acting on an application for a potential competitor, that may have a negative impact on your business if the person down the street who didn't have a liquor license and you have a liquor license is seeking a liquor license. By acting on that application, it could implicate a financial interest of your business, so shy away from that. And again, that goes for both you and your family. Now, what to do if the situation arises where you see this application come in? It doesn't prevent your family members from filing. If you're a ZBA member and your mom needs a variance for her porch, it doesn't mean that she can't do that, right? That she can't file, but it means that you have to recuse yourself. So that's the action that you can take. And remember, you don't have to disclose the reason for recusing yourself. I mean, sometimes it's quite obvious, but other times it's not obvious. And it's no one's right to request that you voice the reason for recusing yourself. Recusing yourself is enough. Okay, here are some other examples. Obvious ones. You live next to the development that's coming before you. You have an interest. And it's not necessarily financially tangible, but maybe it's going to increase the value of the house. Maybe it's going to decrease the value of the house. A school committee member is married to a teacher at the high school. Okay, so that in and of itself isn't a conflict, but it's when you're acting on something involving that teacher. So you're bargaining the collective bargaining agreement, or you're proposing the budget with increases. Same thing for the selectman whose daughter is a police officer. He or she cannot act on that budget item when it comes before the selectman to put on the warrant. You got to recuse yourself. Same thing for negotiating the collective bargaining agreements. And if anyone has a question, please feel free to jump in, just shout or raise your hand. Oh, yeah.
I suppose I just, like on that school committee thing,
Yep.
I mean, if you were not involved in the bargaining, negotiating or anything like that, but then it came up for a school committee vote, you'd still not vote?
You still don't vote on it. So I've had situations where, the interrelation of people, especially in small towns, so you have one selectman get up and leave the room when they're voting one budget item, then they comes and sits back down and another selectman gets up, because they all have different, so you have constant moving parts, but don't vote on it. You're right.
That's an important component. Should they be leaving the room?
It's better to leave the room. I mean, of course, you can always listen, but it's better because there is sometimes a feeling of pressure that that person may exude by simply being a presence there. So I advise to be cautious to leave, but it's not necessarily a requirement.
I can clarify that. The state ethics board said that if there's any kind of influence, we should leave the area. And that's also body language or anything of that nature.
You can be giving a hard stare, and it has a huge impact. But I mean, you can also sit in an innocuous way and not impact anyone. So it's a judgment call, but I recommend to be cautious to leave.
They said to me that even the appearance of an influence, so it doesn't have to be proven, doesn't have to be negated. Even the appearance of the fact that somebody sat and thought that they might happen,
Yeah.
that's a conflict.
Yep. Okay, so self-dealing exemptions. Disclosure. So in certain circumstances, a disclosure is the appropriate avenue. You don't have to recuse yourself. It could be that it's so tenuous what's going on with the conflict that it's not going to impact your decision at all. It's not going to impact the process at all. So you can file a disclosure and you can talk with me about whether the particular circumstances warrant that. But it was discussed publicly. For example, Mary, who never was the town administrator, became the town administrator, and she has to sign payroll. Completely ministerial. She doesn't set the payroll. She doesn't determine anything. But a contract which implicated her son, which she didn't select, wasn't involved in, it's not even directly a town contract. We said, let's just be cautious. Let's file a disclosure. No big deal. So that gets filed with the appointing authority, and they make the decision. Now, there are also things that come before the selectmen or the water commission which affect everybody, including those folks who sit on those boards and commissions. And that's not something that's going to disqualify you. So let's talk about what financial implications could be. Raising taxes, right? Putting something on for an override ballot. That's going to affect everyone in town, so it's not prohibited by the conflicts laws because the impact is townwide. Now, the appearance of a conflict, and this is one that's very, 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 very tricky. And this is one that you can get two lawyers who sit in the same room and disagree completely on. And reasonably disagree on, because it's really fungible. It's not, there are no bright line rules, and it's just whether or not a reasonable person would think that because of a relationship or because of a financial connection, it's influencing the decision. And the reasonable person standard, I mean, it's an objectively reasonable person. It's not a person with an interest who's making this decision. It's an objectively reasonable person. So what I say, if it occurs to you, it's something that triggers something in your mind to say, I wonder if that's a conflict. Think of it as be cautious, and think of it as being an appearance of a conflict, because it even crossed your mind. Sometimes it won't cross your mind, and I don't know what to say then because it didn't cross your mind. But if it does cross your mind, the way to get around it is make a public disclosure of the facts, and then people are put on notice of the possibility of this conflict being there, and it resolves the issue. But again, this is one that people get tripped up in on a routine basis, and it's not so clear. But just try to be very, very cautious when you're dealing in any application in which you have history with, and think about that history carefully. Oh, and speaking of that, I want to go back to appearance of a conflict, even though I didn't flip it. This is where it's triggered If it's not your immediate family member, so one of the categories of folks that I identified for you, that's when it could be triggered as well. So if it's your cousin, if it's your best friend, if it's your favorite school teacher, Wes, I'm sure that's everyone in the town of Hanson with you, that could be an appearance of conflict if you're acting on their behalf, right? So be cautious of those relationships. Confidential information. This is really important mostly for staff that are dealing with personnel information and mostly for boards who are dealing in executive session. So we all know that executive session happens, and somehow a reporter about 2.5 seconds after the executive session adjourns gets wind of what happens in the executive session.
That's a slow report.
I know, it's shocking. Presuming that reporter has not stashed a microphone in here, it's possible that information was leaked. That's inappropriate. It's information that should be protected, and it's a violation of the conflict of interest law to do so, subject to penalty. So remember, even though you may think it's a matter that's of public concern or something else, you think it's important that people should know, you've taken an oath as a board or committee member to abide by the board's decisions, and going into executive session is one of those decisions, so don't disclose. Same thing with personnel issues. If you get wind that someone was stealing funds and the Board of Selectmen took it up and you know that there's a discipline in the file, don't disclose that either. Not only is it a conflict of interest problem, but it could be a privacy issue too, a violation of the Privacy Act, so don't do it. Multiple positions. Let me make sure that I switch. Oh, see, somehow I'm skipping. Oh yeah, here we go. Multiple positions. So, again, you can't have multiple financial interests with the town, so that includes your contract. So your contract can be just your employment with the town. You can't hold multiple positions as a general matter. So here the example is the town clerk can't accept a part-time position at the library, even if it's on a Saturday, so it doesn't conflict with her duties as a town clerk, and she's here 8:30 to 4:30. She can't take that second position unless other circumstances allow her to. And why is that? It's because you don't want to be perceived as having an inside track, right? Because you work for the town, you know the appointing authority. You got the Board of Selectmen, the files for, whatever, X, Y, and Z, and as a consequence, that Board of Selectmen knows you to be a good, reliable person, and they flip that other position to you. It's called the inside track, and it's prohibited generally to have two positions. There are a ton of exceptions to this rule, a ton. So don't shy away from it. If it's something that you want to pursue, you've got to really fully vet it. So call firefighters, reserve officers, they're the easy examples of exceptions. More importantly, when we have a budgetary crisis and we're leaving positions vacant, and another person is picking up the duties, but maybe you're not going to pay the full salary, but you want to give them a stipend for really stepping up to the plate. We, as lawyers, can work to make sure that it's compliant with the law. You can modify job descriptions. You can negotiate side letters of agreement with the union if you're a union member, all to allow you to do these double duties and get paid for it, so you're not, busting your tail without any compensation for the benefit of the town, but we have to do it in a way that's compliant. More importantly, for your board members, obviously you're not getting paid big bucks to sit on your committees and boards, so there are certain circumstances where it's appropriate to take a second position with the town. Multiple unpaid positions are fine. But be mindful too that it's always a big pitfall that people say, well, if I'm working for the town and I go for an elected position, then maybe it's not a conflict. It's not necessarily not a conflict. if that makes sense. That's like a triple negative. But just check with us if you're taking a second position, paid, unpaid, elected, appointed, whatever the case may be, because there are a lot of factors that weigh into whether or not it's a conflict. Some things can be resolved through a disclosure, through an adjustment of a job description, or just because it's not a conflict. Other things can be resolved if there's competitive bidding, for example, responding to an RFP, or there's been public posting of the open position and no one applies, that kind of thing. So there are all kinds of exceptions on that particular restriction. After hours restriction. Hold on, get there. Now, this is accepting money from other sources where there's an incompatibility. So here, the example is a police officer not accepting employment as a security guard because there may be different responses a police officer would take to a certain circumstances compared to a security guard. I also think it's because in this situation, a police officer should respond generally to a crime in his capacity as a police officer first. But there are other examples of this as well. Clearly, if the matter involves the town. Here, let's get there. If the matter involves the town, you're in one capacity at 8:30 to 4:30, can't be acting on behalf of the town, and then 4:35, you work against the town. So you act as a consultant, for example, to another person to tell them the inner workings of the town and what to do and how to advocate and where to lobby. You can't represent or act as agent before a body of the town. So, for example, an attorney is easy. Agent is sometimes easy, but think of it this way. An agent isn't necessarily the person who stands before the planning board and makes a presentation, but it can also be a person who's making phone calls in private and say, push this one through. This one's a good application. So that kind of more subtle approach, or even meeting up with people in the bathroom and saying, this is a great application. Can't be doing that as an agent for the applicant. Obviously, the one standing before and making the presentation is blatantly inappropriate. So there are more exceptions to this rule for outside employment, after hours restrictions, and that's the special municipal employee. And despite the fact that you are all special, you may not be. So the only way you become a special municipal employee is by vote of the Board of Selectmen. I'm not sure who in Hanson has been selected to be a special municipal employee, but that list goes on file with the town clerk and is also filed with the Ethics Commission. So then you can see whether or not you're a special municipal employee. It's important to note that specials aren't done on an individual basis, so it can't be the selectman decides Cape Fetter office is special, but my boss, Jay Tellerman's not a special. It's like lawyers are specials or they're not. Conservation Commission members are specials or they're not. So it's a category of folks that the determination is made.
It goes by the position, not the individual.
Exactly right, Mary.
How often should that be voted? I mean, we haven't voted the special municipal employees since I've been here.
In years, and it's so funny because we had this exact same scenario happen in another town where they didn't know that there were special employees, and they found this old letter from 10 years prior. Mm-hmm. And no one was aware. So the answer is there are no hard and fast rules. And once you're a special unless it's revoked.
Okay. So
it's not like a reappointment or something like that. Right. So that's why it does get lost in the paperwork sometimes. So speak to your outgoing members and ask them. because even the administration isn't always
I can
consistent.
probably find it, but I'm just saying for everybody here.
Yeah.
We haven't done it, and everybody in this room is probably a special employee.
Yeah,
Because the list, when I did see it,
was
it was
long.
long.
Yeah. No, so again, there are no hard and fast rules, and once you're a special, you're a special. So. Okay. After service. So once you leave, and you guys all do a big sigh of relief, thrilled for being done with the town completely, you're still bound by the conflict of interest law. And depending upon what matter it is, you're either on a 1-year ban or a forever ban. So the long and the short of it is, if it's something that you personally worked on and were a part of, it's a forever ban. If it's something that someone under you worked on and you're aware of, it's a 1-year ban. So the example that's given is if you're on the planning board and you help draft legislation for town meeting to approve, you may be privy to information, say, that I gave you on the weaknesses of a bylaw, or the or the benefits, or where there are holes, where there are gaps that were never filled in. You can't work to challenge that bylaw on those grounds because you have essentially inside information. But the example that's given in some of the guidance is if you're a town administrator and your assistant town administrator worked on a particular contract, you're that assistant town administrator's boss, so ultimately that lies with you, but you didn't personally work on it, that's a 1-year ban. But again, complicated stuff. If you're coming back and working in a different capacity or working for residents before boards come, you can ask us and we'll help you navigate that. Why is there the 1-year ban too on some of these things? It's because if you were a planning board member, you have a certain amount of cachet, and then you go before the zoning board, those folks may know you. You may have a lot more sway than Joe Blow, who comes off the street and advocates for that same application. Maybe it's because you've acquired information and sophistication because of your experience, but maybe it's because you have personal connections. So that's why they have that cooling off period. And again, the cooling off a period, like the family stuff, it applies to your partners. So, you know, if I'm working as the town attorney and I come back and someone from I leave, I get canned, and one of my partners or colleagues who work in my firm can't come and represent applicants before the ZBA for that year. So there is that cooling off period for them as well. And that's it on conflicts. Does anyone have a question? Yes.
So I'm the beach director, and like all of my staff members from Lessons get usually gift cards from multiple families. Is it like $50 limit per person like giving it to you, or in total? Because a lot of families will give like $10 Dunkin' Donuts gift cards after swim lessons, or
Yeah, and
whatnot.
so it would be to the individual, right?
Okay.
Because this is all individual. So, for example, everything on the conflict of interest law is an individual basis. So if I decide to act on an application, that's my personal choice, and the town's not responsible. So same thing for gifts; it's on an individual basis.
Okay.
We have a reporting body here in town, or is it always just going right to the state?
So you can report, but to a body, but they wouldn't have any enforcement authority under 268A. Now, it could be that your personnel policies, and I'm not sure about Hanson, reflect that you have to abide by 268A. otherwise you're in violation of the personnel policy, and then you may have a personnel action against you through the Board of Selectmen. But to actually enforce this chapter, this general law, it's always with the state. Okay. I'm moving faster than the other group, so feel thankful for that. I tend to jabber on. All right, so next we have open meeting law. And this is probably more important for the folks on the boards and commissions than staff, but staff also advise these boards and commissions, so it's good information to have. So under the open meeting law, the AG is responsible for enforcing, and the specific division, the lawyers involved in enforcing that are their Division of Open Government, or DOG. And they've issued rules and regs regarding the open meeting law to help clarify what the actual law is and procedures, etc. And that's where all your complaints get filed with the DOG. So a public body is broad. It's any board, commission, committee. Subcommittee is something that may be created unwittingly. So be mindful. Where it's not a subcommittee is where it's a person with individual authority. So say the town administrator is responsible for a certain function, but she decides to get the assessor, the treasurer, someone else involved in helping her decide what to do. That wouldn't be a subcommittee. It's always created by a body, but you can do it unwittingly. So for example, you assign 2 members to do something and report back to you. That could create a subcommittee. And then the subcommittee is responsible for complying with the open meeting law to the same extent as that initial public body, the parent body. So be careful when you're telling people in your committee what to do. Not where to go, but you can always tell them that. But don't tell them what to do and give them a directive to do something. Deliberations. This is virtually anything within the body's jurisdiction. The communication can be via email, via phone, meeting at a social club, talking directly to the person. So be careful when you're with a quorum and discussing any matter about which the public body will be responsible for making a decision on. So if you go down to the pub and 3 of you are there, don't talk about your applications, even if it's super funny and interesting. Don't do it, because you could be violating the open meeting law. The one thing that doesn't constitute deliberation is when you're dispersing agenda information, trying to schedule a meeting, where, when, how, that kind of stuff. I will say there's one caveat to dispensing information, and that includes you providing your own opinion to a quorum of the board, but we can get to that later. But the general scheduling stuff is fine to do. Intentional violation. So obviously, intentional, you know what that is. It's specific intent to violate the law. But important, and I think the time it's implicated frequently is when you're a repeat violator. So if you keep on messing up in the same way, there's no way that you can't be intending to do it. I mean, there's always an exception to that rule, but if you keep on sending out emails to the entire board saying, I'm really upset that so-and-so is disturbing the wetlands, and you've done it once and you've done it twice and now you've done it the 3rd time, that's going to be intentional. I mean, that's an obvious example, but, even leaving the topics, sometimes it happens naturally, but leaving topics and going off into unposted topics, that can also be deemed intentional if you continuously do it. and don't rein it in. So act in good faith, try your hardest to comply, and don't continue to mess up in the same way. You can mess up in different ways, just not in the same way. But I will say too, you're considered to really understand this law because you had to do the online training, you have this training with me, so you're deemed by the state to understand the law, and they impose upon you the responsibility of seeking help when you don't understand it. So be mindful of that. A meeting. A meeting includes all deliberations of the public body except, and this is important for your Concom, your ZBA, your planning board, even the Board of Selectmen did a site visit the other day at a marijuana facility. But you can have a quorum, meet on site. You can't deliberate when you're there. So if you're planning on doing that, and if the applicant is willing, I sometimes suggest that you go in smaller groups that don't amount to a quorum, because I think as a practical matter, it's helpful to comment and to ask questions and to really gather information, because otherwise you're just standing there trying to remember in the corner of that building, did it have a, something or other that I noticed and I don't know what that really was. And then you have to try to describe that at a public meeting, which can be cumbersome and difficult, right? So I try to say it's better to go in smaller groups if you can possibly do it. But either way, you can do it so long as you don't deliberate, you're fine and you're not violating the open meeting law. Private gathering, social event, all that stuff is permissible. Your entire board can go to the prom together and it's no problem, but don't deliberate while you're there either. So again, if you're at the pub and you're having a beer with your colleagues, don't talk about the applications before you, because that would be a violation. Another public body, if they've properly posted, you can attend, but again, be mindful of the deliberation. So that's why oftentimes two public bodies, if it's a hot topic, you have applicants appearing before multiple bodies and they want to see what the other body is doing. If they suspect a quorum of their body is going to be there, they double post. And then it allows them to really engage in the process without being fearful that they might step in something and commit a violation. Quasi-judicial board, that's not really going to impact you. And town meeting, of course, you can go to town meeting. One member of my last session raised the issue of whether or not he could vote at town meeting. Yes, please vote. You're a resident of the town and you have an interest, and you're just one of many who are going to town meeting. So go and vote. Go and voice your opinion. It's my recommendation that you say, I'm here, I'm on the planning board, but I'm here as Joe Blow because I think this is important to the town. Unless the board has said, hey, tell them what the planning board did on X date, and oftentimes the chairman will give a presentation if it's important to that board. So, but yes, be part of the democratic process. Another thing that was raised by Laura about town meeting was sometimes, for example, the selectmen or the planning board may post a meeting at the same time as town meeting because they need to, so it's more typical with the Board of Selectmen, they need to vote on articles that they didn't vote on, and they wanted to hear the presentation of town meeting before they committed. So they will be subject to the open meeting law in that instance. So be careful of that. What are you required to do? You're required to post notice, and you get that. Do you get it to Beth or do you get it to an IT person?
Beth.
Okay, so you get, obviously she posts outside the clerk office and the bulletin board. She's in charge of that. But the IT person, do you also send it to?
No, everybody can post this stuff on the website themselves.
Oh, you guys
Or
are.
some committees can anyway.
Oh, you're technically advanced. Okay, so you have to post. And again, this is your obligation. So if something gets screwed up, you missed a day, it can't be blamed on the town clerk at all. It's your body who is responsible for posting, for getting the information to Beth well ahead of time, well ahead of the 48 hours as recommended, because blips can happen. So the notice must include the purpose of the meeting, right? That's your agenda. So it's the list of items you intend to talk about that you anticipate as the chair and you've put together. But it has to be reasonably descriptive. It doesn't need to be 10 pages long, but for example, common things are name, address, what's being discussed. So is it a notice of intent? Is it a subdivision? Whatever it is. So post those things. Now remember, your boards and committees have different legal posting requirements for certain hearings that are statutory and apart from the open meeting law. So you have to comply with those in terms of advertising and abutters. So again, you post it at the clerk's office, she posts it on the bulletin board, and it also gets posted on the web. The web posting satisfies your requirement, because a lot of towns don't have this outdoor bulletin board, so it satisfies your requirement for the 24/7 period, so you should be set.
So the 24/7 has only come around because of the web.
No, so it used to, that's why some communities have this outdoor bulletin board, and that's considered 24/7, although I'd have to drive in my car, get out of my car and look at the bulletin board. But other communities used to do like an electronic sign that they put in the window that would list Conservation Committee, and it would like stream across, or they might have like a TV monitor. So that's how they accomplished that before.
Community access?
So the alternative posting has to be approved by the selectmen, and I've never seen a board of selectmen approve community access as a mechanism, because I don't know. Not everyone, and also I don't think it stays there solid, like it flashes up different things.
Right, you'd have to watch.
So I don't
it
think
for
that
so
would
long.
work. It would be feasible anyway, but the Board of Selectmen also hasn't approved it. And someone noted to me that this Board of Selectmen requires, per some bylaw or rule or reg, that it be posted outside the clerk's office and on the web. So you have a separate requirement apart from the open meeting law, yeah. Okay, so what's sufficient? Here's an example where the AG found it wasn't sufficient, the posting, the agenda that they had noted, because it was an extension and it was not identified as a public hearing, whereas there were other public hearings listed. And I think the driving force behind that is one of the things so really what sufficiency is about is, if I'm sitting at home and I click on the website and I see what's on the Conservation Commission's agenda, is it going to compel me to go out there because of what's stated on there? Do I have enough information to decide whether or not I'm going to get off my couch and go, or it doesn't affect me, so I'm going to stay at home? So I think where they were driving at here is they felt that a public hearing is a different animal, in that in a public hearing, the public's allowed to participate. Whereas in a public meeting, and we'll get to this, you as chair can decide whether or not people are going to participate and to what extent. So I think that was the driving force there, because if folks thought that it wasn't a public hearing where they had the right to go up there and voice their objections and say they were completely against the extension, you had a different motivation. So I think that's really where they were driving at. But I've seen all kinds of things where it's just so obscure no one knows what the heck you're talking about. If it just lists a company name, you have no idea what they're there for, what the board's intention is. Just read it as if you don't have the history that you all do have. Read it as if you're a person sitting on their couch at home. Okay. Now, executive session sufficiency is a little bit different, right? So you have all these exemptions to the open meeting law, which can allow you to go into closed session, executive session. And the question always becomes, well, what do I put on the executive session notice so I don't either embarrass the employee who's coming before the selectmen because perhaps it's a complaint against them, or identify the property because we want to buy it, but we're not sure we want to let them know we want to buy it. So the AG has been a little more strict, but the Superior Court came back with a decision which flipped the AG's ruling and said that you can't impose additional requirements beyond what's in the law on public bodies. So they said in certain circumstances, the additional information that the AG would like to see is not required. And it can be because it's going to impact your ability to effectively bargain or deal with this employee, or it affects that employee's privacy right, or it affects the ability of you to strike a deal with a person who's selling their property. So in this situation, it was naming the litigants of a legal action. So they just listed the section that allowed them to go into executive session, and they didn't identify the case, Hanson v. Smith or something like that. And they said that was okay. Really important in the context, especially if you're thinking about suing someone, but you're not sure if you want to pull that trigger, and you don't want to notify them. That could be a way you can rely on that case to get out of that requirement, but to identify them. So again, the DOG has approved the municipal website as the alternative posting mechanism, and now with amendments to the regs, they've specified the grace period to be that if the web is down for less than 6 hours, you're still allowed to go forward with your meeting. So please feel free to do that. A notification has to be made to the AG of alternative posting, and again, it's the Board of Selectmen, which we've already discussed, has their own rules for posting. Emergency situations. So you're required to post everything you're going to discuss more than 48 hours ahead of your meeting, but sometimes stuff happens and you need to get a decision of the board to effectuate a goal, and you don't have sufficient time. And if it's an unexpected situation, and it requires you to act immediately, you can go ahead and post it. You still have to post it. Don't just go in there 2 days later. But if you're at hour 40, post it at hour 40, and then go ahead with discussing that topic. So, and sometimes it's just accidents happen. Like I had a board, and they were about to lose a grant if the Board of Selectmen didn't act on an application, and it was less than 48 hours. So we didn't have time to and there was like a holiday or something too. So we didn't have time to comply, but we didn't want to lose $100,000 that we were getting. So we posted on the emergency exception. It was appealed, and the AG said no problem. Remote participation. So if, and I'm going to make a correction here, if authorized by the Board of Selectmen, you may have remote participation. So someone who can't make it to the meeting but really wants to attend can call in. And how can they do it? They can call in. One Board of Health member said, can we use FaceTime on the iPhone? Yep, that's acceptable. Some web chatting, whatever you do here, that's acceptable. You don't need to be seen, but you have to be heard. Yeah, so you can't text. That's not allowed as participating. You can't email. You can't web chat where it's only typing. It has to be audio. Going further into how to conduct a meeting, it's the chair who's in charge. You're in charge of your meeting. If it starts to get unruly, you shut that down. So And if it's not a public hearing, you don't have to let members of the public comment. Sometimes you want to let them comment because you're interested in hearing what the public's opinion is on a certain topic, but you're not required to under the open meeting law. Further, if you decide to allow comment, you can shut it down. It's unproductive, or it's repetitive, or it's devolved into something that's not courteous, or you're starting to see mudslinging. So shut that down if you need to. And remember, people have to approach you, and it's up to every board how they run their meeting, but they can raise their hand or they can come to a mic or whatever, but they need permission of the chair to speak. It can be formal, it can be like a nod of the head, or it can be, even members of the board sometimes are so formal that they say, through the chair, and they ask a question of an engineer or something like that. So it can be that formal, or it can be a lot less, where it's just understood to just maintain some decorum and we're going to allow it to happen. So again, you run your meeting how you want to run your meeting. Provided everyone can hear you, that's sufficient. In the audience, that's sufficient for complying with the open meeting law. This is more on... Okay, so going back, sorry, this got a little bit mixed up, but going back, the Board of Selectmen, if they've authorized remote participation, the chair has to announce that the person's physically unable to attend. You used to have to satisfy one of 5 different, reasons for not being able to attend. Here they just said, you can't physically attend. I can't get there for whatever reason. My tire blew up or I'm in the hospital. It doesn't matter the reason, you can't physically be there. How they do it is up to the chairman, and again, we've talked about the fact that you just have to be audible in your participation. So the members have to hear you, you have to hear them. A quorum, however, must physically be present, so everyone can't call in, because that would be strange. But even one person can't show up. You need a quorum, and then the few stragglers can call in to the meeting. So, and when you do have the meeting with remote participation, you have to have every vote as being a roll call vote. You normally do a roll call in executive session, but you do a roll call if there's remote participation, because they want to kind of identify who's voting where. And you have to announce it, that they're unable to attend. That has to be reflected in your minutes. And if something goes awry, they can shut it down. So the chair has, again, discretion to say, the technology isn't working, so we're not continuing on this way. This is really, email is really important on the open meeting law, because violations occur repeatedly through email on the open meeting law. And the biggest cause of it is the reply all button. So if I send an email, and I've learned to not put it in the to line, I actually put it in the BCC line, if I remember, so that people can't reply all, and then everyone from the committee or board gets the response. Because it doesn't matter, I can send you a million emails with my thoughts on things, and it's not a violation because I'm not a member of your body. But if someone responds to something that I say, that is deliberation, even if it's one-sided, even if your board members don't respond. So don't hit reply all. Further, another violation could be serial communication, where you forward along, you have a 5-member committee and Joe emails someone on his committee, and then that committee member forwards it along. Even if it's by an accident, he didn't realize that the whole thread was going to show up, that's a violation. It doesn't matter if it's an accident or on purpose, so it would still be a violation. And in terms of distribution, we already said distribution of documents for the meeting is not a violation, but be mindful, if you've prepared the document that's gonna be distributed. So if I wrote a letter, say I'm on a conservation commission and I have strong feelings about a particular application, but I can't make it. So I write a letter and say, hey, I want you guys to read this at open session, and you distribute it. That could be a violation because you voiced your opinion on an application to a quorum, not in a public body. And that was the biggest thing that a case recently came down where selectmen were individually creating evaluations of the town administrator. And you do that because it's cumbersome to do that in a meeting. So you just do your own sheet and then you send it to the chairman who compiles that information. And then the evaluation is based on the entire board's evaluation, that's a composite evaluation. And the AG found that to be a violation. And the SJ, I think it went up to the SJC. It went somewhere. Anyway, a court said that is a violation of the open meeting law because it's an expression of the members' opinions. The way you can avoid all of that is by publicly posting at the same time when you distribute to the committee members. So had they put the composite or the evaluations on the web, so sometimes towns publish the entire packet for the meeting, it wouldn't have been a violation because there would have been contemporaneous public disclosure. So just be mindful, email is tricky. Yes.
Somebody wants something read at a meeting. How would they go about doing that if they weren't unable to be there?
So what you can do is, I'd say, do you have staff? So are you conservation?
You have a director.
Yeah,
She's in staff.
right.
Director.
Give it to the director.
To read.
Yep.
I just have a question for you that I'm looking through this. With email, like, what about Facebook? Like, what if people are posting their opinions on Facebook?
Yeah.
Does that violate?
This is uncharted waters, but something that I'm super concerned about, because if you have if a quorum is accessing the, I don't know, Friends of Hanson page or whatever your local page is, the patch or whatever, that could be a violation of the open meeting law if you're talking about an application that's coming before you. Not only could it be a violation of the open meeting law, but you could also have a due process claim. You could have privacy. You could, if it devolves, you could have slander. But let's presume it's just all on the up and up of how they feel about the application. As a board, you're responsible to give people a fair opportunity to make their case before you. You're not supposed to prejudge these applications. So you're supposed to base it on the evidence, and it may include information that you know in your brain, and you can articulate that. You can say, actually, I know the traffic on Main Street is horrendous at whatever time, and this is going to be a huge... So that's not anything they've presented to you, but you know. You can rely on that information, but you have to give them a fair opportunity to make their case to you. So, to be frank, I think Facebook is a really dangerous thing. And for maybe some of these committees, it's less frequently used. It's actually the selectmen who need to use that in some senses to talk about their platform and to talk about what their positions are on certain issues. I get that piece. But when you're talking about specific applications, shy away from it if you can. My recommendation. It's a cautionary matter. There has not been a single case that I know of that addresses this, but it's gonna come because it's used all the time. I mean, I don't know about tweeting because I don't know how that works, but I know it's the same. What's that?
Just out of curiosity, did this topic of Facebook come up at the previous training?
No, it didn't. Am I stepping inside here?
So with the employee body, they go to the directors, for the elected body, they go to the chair. where they wanna have something read.
Yes, and again, remember, something between two people, if you're a 5-member board, isn't deliberation because you need a quorum. So yeah, if you need the chair to, or it's better if it's the chair, but say the chair is out of town and you've got another
board
member, yeah, you can give it to them, for sure. Matt?
So I just wanted to kind of throw into Facebook.
Yeah.
Wes and I, when we first were elected to office, we went to the Mass Municipal training.
Yeah.
And they talked about open meeting and stuff. And one thing that they also cautioned about Facebook was even if, just say someone posted something about let's build a statue of Matt Dyer, and just saying.
I get that call every week.
Just say someone's had a position.
Yep.
And three people out of a 5-person board liked that on Facebook, although they didn't say something, but they liked it. That's a violation of open meeting law because it's a quorum.
They
Yeah.
expressed an opinion.
And which is super funny because, and I'll be honest with you, I have a Facebook page, but I don't use it all that often, so I don't know about likes. But I think sometimes people like it with the intention of like saying they don't like it too, because I don't know if there's a dislike thing.
There is now.
Oh, there
You
is.
can dislike it, you can be angry at it, you can be sad at it, there's a lot.
Okay.
It's a great thing.
But either way, even if you're liking or disliking, you're expressing your opinion on something, even if people misconstrue it. Right.
Not words. You're
Right.
expressing an opinion.
It's exactly right. It's exactly right.
So one quick question, because this did come up at Recreation last night, was if there's a government, Town of Hanson Facebook page about something, and someone wrote a nasty opinion, they were, vulgar in their comments, what's the proper way to delete that? Because you don't want to delete that comment because you're hypothetically deleting
A public record.
a public record, because that's how one opinion was at this training was every comment is a public record.
Yes. It's so complicated because there are retention requirements for a public record, and theoretically, if it's a record created in connection with your official duties, that's a public record, right? So if you have a private email, but you're using your email to communicate with residents about town business, that's all public record, even though it's not at hansonmassachusetts.gov. So you also have, and was it posted on the Hanson website?
No, it was on the Hanson, the Recusal Facebook page.
So I don't know how you can't delete someone else's post.
You can if you're an
If you're the administrator of the page,
Yes.
Oh,
you can, but the administrator you said keeps it on the,
Yeah,
it doesn't
so
delete
it
it.
deletes it from everyone else seeing it, but you can still see it. Like the administrator of the page can still see it.
So wouldn't the way to avoid that is to click no comments, not to allow comments?
oh, you can do that
I don't know. If
Yeah,
you
but
can.
but now you're getting into the reason why they won't touch us with a 10-foot pole is because now you're dictating
It's a
when
First
and
Amendment.
where somebody can check their civil liberties.
Yep.
Right.
Because they're an elected or an appointed member, and that's why they haven't
And
touched
it's a
this.
public
It's a
forum.
Because they haven't been able to sue it because.
No, but it doesn't have to be a public forum, it could just be.
An
informational page.
Informational page only.
Yes.
That's a
Oh,
difference.
you
That's a
can.
difference.
Yes.
That's a
So.
difference. That's a difference.
And that's what you should make it.
So as a matter of fact, I've done a couple of social media policies and worked with towns on their website, and we've done exactly that. This is for information. It's not for everyone to comment or to bash the town or not.
Great example of that is the police department's Facebook page. So that's one way.
Yeah, one way.
Informational only.
And then you haven't, because the way the First Amendment works, without like really going crazy, the way the First Amendment works is first you have to create a public forum, and that's this even exchange. So you can do it with signs, you can do it with your public parks, but you can also do it on the web. And so if you're having an exchange, you can't then take something off because you think it's not appropriate or it's wrong or whatever, unless there's some other unprotected reason, like it's racist or inciting violence or something like that. So there are other reasons why you can take posts off, but you can't take it off just because you disagree. Once you've created that public forum, you've created it, but you can ratchet that back by making it a one-way information providing service for sure.
Isn't the best advice really just don't engage, ever?
I
Don't engage.
am constantly shocked and horrified by the level of engagement that goes on these social media sites because it just leads to problems.
And there are gonna be horrible people who say horrible things, and you just
Yeah.
don't engage.
Well, somehow the social aspect of Facebook or any other of those, Twitter or anything, they've become the norm for municipalities. Unfortunately, municipalities are usually 8 to 10 years behind technology. So the official pages sponsored by the town of Hanson are the web pages that we pay to have administrated. So if a body isn't reaching out to the town administrator's office or the town clerk's office or their own body to publish things on the town's approved and paid for sites, then it shouldn't be considered anything. However, social dictation has made it that people have changed it so that Twitter and Facebook and all the other,
Or
whatever,
official.
you know, Bumble, have become the ways that people communicate. And we probably need to do a better training here, or a better notification that if it hasn't gone through the official pages that we pay for, it's bunkus.
Well, and to be honest, you need to take a look at your social media. You need to look at your social media policy because you need to ensure that other things aren't occurring, namely sexual harassment, right? Other things that are discriminatory practices. All of those things occurring. You need to have clear policies so your employees and your appointed boards and committees are noticed that they can be removed or terminated if they violate that
And
policy.
we have that policy.
We do have a policy.
I mean, I'm not sure, have you reviewed it yet, but
I
before you
reviewed
came
it
in-
about a few minutes before
And I
you
mean,
guys
it's
voted
pretty
on it.
strict.
Oh,
And we have had a couple discussions where no one's been actually removed yet, but
Yeah.
it has been discussed because of their social media
Yeah.
behavior.
Right, because, and this is beyond open meeting law, but exactly what I said about, as a board member, you're a representative of the town, and you don't want someone who's an applicant, I'll give you the discrimination card because it's just super easy to deal with, to feel like they're not gonna get a fair shake before you because you posted something that you thought was funny, but was actually pretty horrifying to them, and it was ethnically, inappropriate or whatever, sexually inappropriate. You want to make sure that they feel like they're going to be treated fairly when they come to you as a board. So that's my, yeah.
So, if, as long as we're providing some other venue for public forum, for commenting, like a meeting even, does that cover you?
Yeah, so you don't have to provide a public forum for anything. I mean, yeah, a meeting it has to be public.
Right.
But you don't have to create a public forum. I mean, certain forums are already public anyway, just by their nature.
But if somebody wanted to express an opinion or talk about something, as long as you're providing a meeting or something else, some way of communication for them to get in touch with you, it's.
If it's coming
You can turn
before
on
you
comments on
naturally,
Facebook.
even if it's coming before you naturally, you don't have to post a meeting just to accommodate someone's desire to discuss a topic. You create your agendas.
Right, it has to be on the agenda.
Right.
Yeah.
No. Okay.
I mean, if someone feels strongly about someone, they can pick it in a public forum or do something like that. I mean, I don't want to give people ideas.
I've already had those ideas.
So, Mary. What's happening here? Oh, here we go. I'm back.
Okay.
So that really went off topic, but I think that was productive.
Absolutely. Still having fun with tomatoes.
We talked about the town administrator's evaluation, so I won't go into that. Serial communication. Okay, so this happens with boards and committees all the time, right? I know that something's coming up as a board member, and I don't want to feel embarrassed by being the only no vote, right? So I'm going to poll my committee, and I'm going to say, hey, Frank, how are you voting on this project? Let's talk about it. Let me get the rundown. And then I go to the next committee member, and I said, Frank told me he's voting with me. Where's your vote? So that, even though 3 people weren't present for any of the conversations, in together, they're serial communication of violation. Don't say, who do you think we should, of the 3 applicants, which one are you gonna choose? You know, so don't do any of those things, because even if you're talking to one person, if it goes on to the next person, and that's a quorum violation. Again, expression of an opinion of one member because they hit reply all and they said, hey, I'm gonna definitely clean up, haul those people in for that Concom violation, and I'm going to bring them to their knees. Okay, even if no one else responds, it's a violation. Executive session. Several exceptions to open meeting where the public has a right to be there and listen to the deliberations are found in the executive session section. First is complaints against the employee. Again, that's not professional competence. So if you feel like someone's just doing a bad job, and that's not something that should be discussed in executive session. But if it's, so-and-so is, it needs to be terminated because of X, Y, and Z, that's something that's right for executive session. Strategy sessions, and I'm going to combine these next two. Strategy sessions for collective bargaining, strategy sessions for non-union personnel contract negotiations, as well as the actual negotiations for collective bargaining, or the actual negotiations of the contract. Remember, everything then has to be ratified and adopted publicly, but all those preliminary work can be done in executive session. We just had a Board of Selectmen executive session for that very reason. Litigation. This can be if it's active litigation, so you have a case against the ZBA that's pending and we're coming in to give you an update, for example, or it can be imminent threat of litigation. Someone writes a letter and intimates that they're going to sue you for a civil rights violation. You call in the lawyer and say, are we going to get sued? What's the liability risk here? You can do that in executive session.
That should end a meeting though.
What's that?
That should end a meeting though, somebody coming in and threatening litigation. Should end a meeting, it's the chair's responsibility to shut that down.
Yes, but if they write you a letter and detail, like a demand letter, for example, I fell at the library and broke my leg, let's talk about what the requirements for 258 are. You can talk about that. So discussion of deployment of security personnel. So I don't know. I think the police chief generally does that. I haven't seen that come up. Criminal misconduct, definitely have seen that. It could be an employee who's done something criminal, stolen money, for example. You can, as the town, decide whether or not to press charges in executive session. Purchase of real property. Obviously, you want to talk about what you are willing to pay. Do you want the full extent of it? All that stuff in executive session. I've never seen this grant and aid requirements come into play, but it must be something like you get a grant. I don't even know what it is. Frankly, I've never seen that come up. I'll cross that bridge when I have to.
That's when you've applied for a grant, been given the grant.
Yeah.
And somebody's questioning your filing for the grant. Maybe somebody else that applied for the grant.
Oh.
That didn't get the grant.
So like a challenge.
Yeah.
Oh, okay, I've never seen that come up. Are you making that up? Oh, okay,
No,
good.
Yeah, no, we just got a grant and we had somebody ask, why was it that we had gotten the grant?
Really?
versus somebody else. That's when I came into play, yeah.
Oh, so interesting. Wow, thank you for teaching me that. Okay, to consider applicants, remember this is only at the preliminary stage, so say you have a pool of 10 and you want to narrow it down to 3, you can do that. in executive session, remember the interviews themselves of your final applicants have to be done in open session, which we can all scream about, because what it does is it says for the 3 applicants who you're interviewing publicly, it notifies their employer that they're looking, but that's the law. A mediator, okay, if you're in litigation, you want to mediate, fine, executive session. Trade secrets, confidential information, security sensitive information, all that stuff, you can understand that too.
Can I just ask a quick question?
Yes.
Because we've always done search committees for various positions.
Yep.
And the board's looking to get just a recruiting service.
Yep.
So the recruiting service gives the board like 6 people to consider.
Mm-hmm.
They have a one shot of going into executive session to interview these 6, or it's different with the Board of Selectmen, they don't get that option of executive session.
So, no,
They do.
they can have that option of, so they can either make a subcommittee and have a smaller group of people refine it, but they're still subject to the same rules.
Mhm.
That committee can go into executive session. The Board of Selectmen can also go into executive
But they
session.
only get one shot at it.
You can have multiple shots too. You can. So, for example, you can look at the resumes in one executive session and say, okay, I'm going to knock out one of these guys because completely not qualified. But you have 5 left. But once you narrow it down to your final set of candidates, whatever that number is, it has to be done in open session.
Okay.
So you
I
can
thought
have
it applied
multiple
differently
shots.
For the board itself.
No.
Wouldn't you just postpone at the end of that, you would postpone that executive session till the next niggas come out of it and they come out of that executive session? Couldn't you
Well,
not table it, but you postpone it?
previously with the search committees, we did that. You know, we're gonna interview like 15 people. So here's the first session, we're still in executive session doing this, narrowing the field. But I was always under the impression if the selectmen did it themselves, they would only get one shot at the executive session and then they'd have to bring the finalists.
Wow, that's a long session.
Yeah, I don't think so, because there could be just logistical problems, like what if everyone can't come in,
Mm-hmm.
you know? So no.
Okay.
Okay. Minutes. So it's not a stenographic transcript, you don't have to record everything, but record a summary, that captures the major highlights. That's really important. So also you have to list the exhibits you used and what are the exhibits, anything you looked at in the meeting. So, and it could be something that you weren't provided in advance, but the applicant says, hey, by the way, I've got this plan from 1918 which says X, Y, and Z. That's an exhibit. You looked at it, you relied on it. Executive session minutes, it's good to have a clear policy of when you should review those minutes, because you have to continuously decide if they're protected. Some are protected forever, but you still have to continuously consider whether or not they still hold that protection.
So who considers that it's a public body?
The board, so if it's the Board of Selectmen that held the executive session, they meet in executive session and discuss whether or not it should be disclosed. So it's not like the Board of Selectmen can swoop down on conservation and decide when you should release your minutes. It's the body, because they're the only ones who should have the appropriate information. But some people do it quarterly, some people do it biannually, some people do it annually, but you should do it regularly.
And you can simply state that in your agenda. You could say, going into an executive, the board going to executive session to discuss executive session minutes.
Yep.
Cool, okay.
Yep. And so what you can, because if it requires substantive discussion, right? And so then this, for example, if you have litigation that's ended and you just know you need to release it because there's no reason to withhold it, you don't go, you just, you say, I vote to release it because the litigation's ended. There may be other reasons to redact if there's attorney-client privilege, so that may require some thought privately, but yeah. Minutes to be approved in a timely manner. It's for open and executive sessions, you've got to approve the minutes. It's the next 3 meetings or 30 days. So if you're a body that meets infrequently, you have a long pass, because you have 3 meetings. It's the longer of the 2. And here they talk about the AG found the minutes to be insufficient because a member of the public, and I'm imagining it was a disgruntled member of the public, his or her comments somehow didn't make it to the minutes despite the fact that she spoke for 20 minutes or whatever. So that's not representative of what really happened. Really what should happen is your minutes someone should be able to read them and have a feeling of they knew what went on at the meeting.
So is that's just approved, that's not approved and posted, it's just approved.
Yeah, so as a matter of fact, provided they're approved, there's no open meeting law requirement to post. Under the public records law, they recommend that you post documents that are, important to people. So minutes are generally posted to just comply with that, but there's no hard and fast rule, and you're not required to post on the open meeting law. I actually had a complaint where someone complained that we weren't posting minutes, and the AG sided with us saying we didn't have to. It's not a requirement. But you should.
Posting on the website.
On the web.
Yeah, they have to be posted with the town clerk.
Yeah.
All the minutes have to be
On the
posted.
website. On the website.
Have to be posted with the town clerk.
She's the keeper of records, and you have to keep your records. You have to keep your minutes as public records.
Yeah, just wanted to make sure that.
Yeah, everyone was like, and we're never giving them to Beth. Beth, I get a red phone call I get a negative emoji from Beth. Exactly. I dislike that. Okay, so here's what happens with the open meeting law and enforcement. A person has 30 days to file. There are exceptions to that. So say they didn't know that there was a violation, say for going into executive session, they didn't have sufficient information to know that could be a violation. It may toll the 30-day time frame from which they could file. But they have 30 days to file. Then you as the body have to meet. You can ultimately designate, say, me or the town administrator to respond to the open meeting law complaint, but you have to meet in order to do that. So sometimes I do it in a number of ways where I get an open meeting law complaint and I can prepare because I see what's gone on, and maybe I know for 100% I have no investigation required, and town administrator calls me up and says, Kate, look into this. I do a draft complaint. You meet within 14 days and you approve my draft response. That's sufficient. Or within 14 days you can meet and designate me to respond. Or you can respond yourself. I've also had that happen too. If the complainant isn't satisfied with your remedial response or your contention that it's not a violation, then they can file with the dog, and then the dog does an investigation, and they actually do a pretty active investigation. They'll call up the board members, they'll interview the complainant, so they actually do a pretty active investigation. Some things are super clear just from the face, but other things they are a little more fact sensitive, so they'll delve into it. Okay, so here are some of the things that they can impose on you if you have violated. Immediate and future compliance is what generally happens if you're not a frequent flyer. They just say, oops, it's an accident, don't do it again. They may require you to attend training. They may make you make certain things public. They may annul your decision. So if you've approved an application or something like that, they may say that's not valid. Or they may, if you're appointing authority, annul the employment decision that you made against the employee, or impose a fine. Remember that fine is for the public body, it's not for the individual who did the violation, so it's really against the town. As we discussed in the beginning, you're all supposed to be familiar with the open meeting law, and you're deemed to understand and know what the requirements are. So all violations could be intentional. I will say again that it's really seen when there are repeat violations. You keep on doing the same thing over and over again. That has to be intentional at that point. Mediation. This is a new provision. So I was telling some of the folks in the prior session that we have one town where there are 3 or 4 open meeting law complaints filed a week. Yeah, and number of public records requests, more than you can count. So in certain circumstances, maybe it makes sense to pull the parties together and say, how can we work together in a better way, rather than constantly be chasing open meeting law complaints because we can't get to regular business. So that's a possibility. I don't know if anyone's done it effectively, but certification, this is important for Beth. So if there have been violations by your board before you were a part of the board, Beth is going to provide you with copies of all those prior violations for the past 5 years. And so that's to avoid repeating violations. But I think there are never any open meeting law complaints in Hanson, so we're good.
Not in 5 years. West didn't get a list, right? I think Miss Beth and I looked and there hadn't been one.
Yeah. So, and that's it on the open meeting law. I have other trainings here that we do, but we already did ethics. Public records is another one we do. But here's all the contact information that you would need for some of these bodies: ethics, public records, Division of Open Government, and my number. And Mary has my cell phone number too. Many of you have my cell phone number. It's right on my email address, signature of black. So.
Is it the state ethics website now, or is it the open meeting law website now, where they actually post your complaint? Is it state ethics? I think it's state ethics.
Open meeting law posts your complaint. There's a PDF of it and the determination. State ethics does not, because usually that stuff is confidential.
Mostly, so it's,
Yeah.
it's open meeting.
Yeah.
That was something 4 or 5 years ago. That was something that they had just recently changed a few years ago.
Oh, is it something that they
It wasn't
changed?
posted all the time.
Yeah, I don't know.
It's on the.
It's in your packet. It's in the end of your packet.
It's in the
It's
back.
Don't call her cell phone, she doesn't answer it. So funny, it's forwarded to Marion.
Can I do that to Mary?
Like it.
Forward me also.
Imagine if you're getting my calls too. That's a really
R72.
That confused me.
So, thank you so
Thank
much.
you.
you
Did
guys.
everybody sign in?
Yep.
I think so. Well, thank you for coming, we
Thank
appreciate that. And for any committee members who were not able to attend, cable will be showing this. And we're encouraging everyone to watch it. We need as much participation as possible.
Will they sign off on it?
Yeah, I'll check with the board to see if we can get emails from people saying that they've actually watched. And there'll be a quiz at the end, and what color was Kate's dress? See if they actually watched.
Was it blue or was it silver?
See ya.
Thank you.